Act, Chapter 84 of the Commonwealth of the Bahamas, a similar electronic monitoring unit was established. Mr. Speaker, I had the opportunity of observing this personally on one of my few official fact-finding trips. One of my few fact-finding trips. This one to the Bahamas. After establishing an electronic monitoring system, and I hope that that doesn't evoke a question from the other side as to who went with me. My wife went, and I paid for her. After establishing an electronic monitoring system spearheaded by this unit in 2010, the Bahamas has had nothing but a series of successes in this regard. Excellent. The system is operating smoothly to date, and the courts are making good use of this newly introducing sentencing option. If I may say so, Mr. Speaker, why did I choose the Bahamas? Because a son of the soil, Justice of Appeal Stanley John, who works as a court of appeal in the Bahamas, called me and he said there's something really good happening in the Bahamas, electronic monitoring. It helps the criminal justice system get on the next flight and come up. But of course I couldn't get on the next flight because you know there's a process. I have to go with a cabinet note and all that sort of thing. And then I eventually went. I saw it for myself. I was able to witness a prisoner under offender management moving in a car to a certain corner, come out of a vehicle, it would seem, and meet another person at a certain street corner. It was that effective, Mr. Speaker. That is what we need here in Trinidad. The whole country will tell us that. That is what we need here in Trinidad and Tobago. And we are bringing it. Mr. Speaker, Clause 7 of the bill would prohibit any officer or employee of the electronic monitoring unit or any individual engaged by a service provider from disclosing any information received in the course of his employment other than in the proper exercise of his functions. Persons contravening this clause commit an offense and could face a fine of up to $100,000 and 2 years imprisonment upon summary conviction. In other words, if you're not confidential, don't look for a job in there. If you can't be responsible, do not look for that kind of work, Mr. Speaker, because this system requires confidence and confidentiality. This is a crucial safeguard installed in this bill in order to protect information gathered and the privacy of anyone that is being monitored. Part 3 of the bill, Mr. Speaker, comprises clauses 8 through 14 and addresses the general application of electronic monitoring orders in addition to key administrative functions. Honorable members, this bill would provide that electronic monitoring may not be imposed as a sentence, as part of a sentence or in lieu of a sentence of imprisonment for the offenses listed in the first schedule to the bill, which would include treason, murder, kidnapping, rape, drug trafficking, and various firearm offenses. As can be seen from the nature of these offenses, Mr. Speaker, our government acknowledges that electronic supervision in the community would not be suitable to violent offenders committing violent crimes, as these type of offenders are deemed high risk and are seen to pose a significant threat to public safety. Electronic monitoring in the community would be, in the most part, geared towards offenders deemed not to pose a serious threat to the public and whose crimes do not necessarily warrant incarceration, in order to effect rehabilitation of the offender, while at the same time protecting the public from undue risk. Clause 9, Mr. Speaker, would provide that before making a decision in respect of the imposition of electronic monitoring, a court shall request a report from the electronic monitoring manager, which will indicate the suitability of the offender as a candidate for electronic monitoring. This report would serve as a guide to the court as to the suitability of an offender for electronic monitoring. Now, Mr. Speaker, you have to understand that this system is but a part, it's part of the broader system for offender management, the policy of which has already been approved by the Cabinet. The Offender Management Bill 2012 is on its way. It is coming, and it is coming shortly, together with the Parole Bill of 2012. These are all interconnected. They will be working together, Mr. Speaker, in order to take us out of the 19th century where we still are. We still have the prison rules of 1838. What a disgrace. When I came into the Ministry of Justice and I met those prison rules, I said, but what has been happening all these years? I mean, I have to give what has to be given to the other side. They started the process. They were at a very advanced stage of it, and we have had to change somewhat in order to bring them in line with the parole policy approved by our government, as well as the offender management policy that has been approved, and the paradigm shift from the retributive philosophy of punishment to that of restorative justice for offenders. You see, Mr. Speaker, while it is I don't want to take part out of what has been done by those who have preceded me in government, and I want to thank them for starting the process, our government has had the wherewithal to take the baton and carry it over the winner's line. And this is but part of that. This was a missing link, Mr. Speaker, in that process. So I thank the other side for the work that has been done in that regard.
But they couldn't finish.
You know, but you know, you don't start something unless you could finish. You know, you don't start something. Like a term in government. When you get a 5-year term, you're supposed to finish the term before you go and ask anybody for a new one. You know? Yes, yes. We'll see about that.
That's what you meant by finish.
We'll see about that. So, Mr. Speaker, Clause 9 would provide that before making a decision in respect of the imposition of electronic monitoring, a court will have the report from the electronic manager. Now, in the Ministry of Justice, perched in the Ministry of Justice is also the probation division of the Ministry of Justice. So there we have the opportunity to have probation officers reporting on a person's suitability. They report and provide a report to the electronic monitoring manager, who provides the court beforehand with all the information that is set out in the schedule to this bill. So this report will inform the court about the general character, antecedents, and physical and mental health of the offender, so that the court may be well poised to determine the possible threat to public safety which may be caused by community supervision of the offender in question. Mr. Speaker, Clause 9 would provide further that the court explain to any person or respondent on whom electronic monitoring is to be imposed with their consent, I emphasize and I repeat, with their consent, the meaning and effect of the electronic monitoring decision, as well as the effect of non-compliance with it. This is a particularly important step, as a clear explanation and demonstration of the device and its operation is paramount. The participant must clearly understand that the use of the device is chiefly an alternative to incarceration, and there would be serious consequences for violation. You breach the term of electronic monitoring, it means that you prefer lockup. Plain and simple.
Your choice.
Plain and simple. The choice is yours. You consent to electronic monitoring and you are outside. You breach the terms of that, you're back inside in lockup. Mr. Speaker, as I had alluded to, this legislation makes provision for electronic monitoring to be imposed as a condition of a protection order issued under the Domestic Violence Act. Law enforcement agencies in many jurisdictions have implemented structured electronic monitoring programs to effectively track defendants, offenders, and victims involved in domestic violence situations. So I am standing up here today, I say, as Minister of Justice, as a member for St. Joseph in this August chamber, I am standing up for all those women and men who have been abused by domestic violence. I am making a big plug for them with this legislation here, to protect them, to protect the order that they have. So when they get an order in the court, it is more than a piece of paper. It will provide them with protection against persons who will follow them, torment them, harass them, Mr. Speaker,
Sometimes kill them.
and sometimes even kill them. So you see, I am for the women of the country. I wish I could have been called a feminist. I really wish I could have been called that, Mr. Speaker. Clause 10 of the bill would provide... Excuse me? Let me finish my presentation. Clause 10 of the bill would provide that electronic monitoring... Yes, sir.
Thank you, Honourable Minister, for giving way. I have looked at Clause 9. I've actually got a copy from the clerk just to make sure I have the correct version of the bill. Where in Clause 9 does it indicate that electronic monitoring can only be imposed with the consent of the person?
It's early time still. It's early time still. I have a number of amendments that will be circulated in the fullness of time. And you would know that the Honourable Member for Diego Martin Northeast was in government for 8 years plus 4, 12 years, you would know. You would know, talking about shame. I don't have to. Next time I will not give away my speaking time to you. Clause 10 of the bill would provide for electronic monitoring, that it may now be imposed as a condition of a pardon granted by the President under Section 87(2)(a) of the Constitution. Conditional pardons are not a foreign concept, as it has been the practice of His Excellency to grant conditional pardons to persons in the past. Clause 11 provides that a competent authority empowered to grant early release from imprisonment may impose electronic monitoring as a condition of such early release. In the case of parole, the eligibility and suitability of certain classes of incarcerated persons